I'm Paul Laney, the retired sheriff from Cass County, North Dakota, and the current vice president of national sales for Turnkey Corrections.
And I'm Lauren Matthews, and I'm the current social media and content specialist for Turnkey.
And you are listening to Jail Talk, and today we have a regular guest, a returning guest, and a requested guest. Many of you saw his legal presentation when we had him on a few months back, and we got a lot of feedback on that. Obviously, legal issues in the jail, the liabilities that go along with that is such a hot topic for anybody in the jail industry and in the law enforcement industry. And we have the luxury of having Mr. Rick Hodsdon with us, well known in the law enforcement world, and we're excited to have you back. And we're going to talk another hot topic today.
Thanks for having me here.
Like Paul said, you've been on the show before, so if everybody wants to hear a real in-depth bio for you, they can go back a few episodes back and check that out. But why don't you give our guests just a little lowdown about yourself?
Yeah, we can't go too long or it'll take the entire time. I mean, I think I've been practicing law since the Garfield administration. Currently, I represent and counsel for the Minnesota Sheriff's Association, which I've been doing since 1987. I've outlasted every sheriff in Minnesota and pretty much around the country, but then not having to stand for election might make a difference. In July of 2020, July 31st, was my retirement date from Washington County Attorney's Office, where I worked for over 33 years. Before that, I spent 8 years with the Attorney General's Office, and I pretty much teach for Northwestern University School of Police Staff Command. As Paul knows, because that's when we first met, I've done a lot of work with the National Sheriff's Association, admitted in multiple courts, including the U.S. Supreme Court, and my kids have pointed out that if and when I retired from my county job, I'd be cutting back to one full-time job, and they've got that right.
Pretty much right, yeah.
Still do a lot of training, teaching, consulting, and that's me in a nutshell.
Well, and I know I'll hit this now, and we'll have the information on the screen at the end of the show. But if you want to bring Rick in for training in your organization, reach out to him directly, and he'll come to your organization and bring you the full-blown. We try to cram a lot into 30 minutes. And we're definitely got three really, really interesting topics today, and one that will reach out to all of you that are listening. But if you want the in-depth classes and you want to really get in-depth, bring Rick right to your facility. And he now has the time to do that a little bit more. So
a little bit more.
So as he said, he's done one full-time job now. And so with that today, when we start talking about the different topics we wanted to cover, this one definitely is a hot topic for all you sheriffs, for all you jail administrators, is the Brady Giglio ruling and the disciplinary actions that go along with that. And Rick knows a lot about that issue. And if any of us in law enforcement leadership positions, we dealt with the Brady Giglio at some point in our careers. And I certainly, as a sheriff, had to deal with it, as most of you all have. So that with that, we're going to talk about Brady Giglio, and you know a little bit about that.
A little bit.
Well, let's just start with what is Brady Giglio?
Right. That's a good fundamental question that everybody, not just on jail side, but everybody, not only in law enforcement, but frankly, everybody in the public sector, anybody who might potentially testify in a court of law. Law enforcement is out ahead of this, but same rule applies to social workers, child protection workers, anybody who might testify in a criminal proceeding. It's important that they know a little bit of this background. Brady is a United States Supreme Court case, Brady versus Maryland. Giglio is a later case, United States versus Giglio. And we tend to, in the profession, shorten up this issue as a Brady Giglio issue. But there's been a substantial evolving body of case law for a long time. Brady was first articulated in 1963, so this is not a new topic. But what's becoming a newer topic or a defining issue is how Brady and Giglio relate to discipline, especially in the public, right now in the public sector, but I'm not sure where this is going to end up for witnesses. So let me give you a quick little background, and I'm going to call him Brady Giglio, but some of the case is not a Brady case. This is evolutionary cases, but in the interest of time and efficiency, I'll just keep calling them the Brady Giglio issues. This doctrine stands for the constitutional proposition that initially the Brady case initially applied only to prosecutors, but it's been extended to law enforcement and other government resources and other government witnesses. It stands for the proposition that prosecutors are ministers of justice and are supposed to do the right and fair thing. And so Brady and its evolved cases stand for proposition that the government has an obligation. In a criminal prosecution, the government has an obligation to be fair. And part of that fairness is to provide to defense counsel or defendants that represent themselves, but I'm primarily going to focus on defense counsel, to provide to defense counsel material exculpatory information. And over time, this obligation has evolved to put a proactive affirmative duty on the government. Initially, like I say, prosecutors, but subsequent case law said the prosecutor's obligations are also extended to agents or representatives of the prosecution, which include law enforcement. And what stands for the proposition that you have to convey and give to defense counsel material exculpatory information, even without being asked. You have, as I say, a proactive affirmative obligation to do that. And what is material exculpatory information? It is something that might, if it's not disclosed to defense counsel, might make an appellate court or the legal system question the fairness of the proceeding. Are we comfortable or confident in the result that justice was done if someone is convicted and this information hadn't been disclosed? And it started out things like impeachment evidence. If I'm going to call, as a prosecutor, if I'm going to call an informant witness who's got a criminal record, I have an affirmative duty to disclose that fact to the defense because they might be able to use that to impeach the credibility. Or if I've made a deal, you plead guilty and testify against your co-conspirator, you're going to get a break on sentencing, those kinds of exculpatory disclosures. If somebody came in and the person confessed, even if to the crime, even if it's a false confession, I would still have to disclose that to the defense. Now, disclosure doesn't necessarily mean I concede it's admissible. In fact, for the new topic that we're going to talk about, how this has evolved toward disciplinary issues, the motto of many prosecutors is disclose and then fight like crazy to keep the jury from ever hearing it. But as I said, over time, in the Brady Giglio jargon, within the last several years, it started on the West Coast, as many things do, and now it's a national topic, a phenomenon, and that is how internal affairs disciplinary matters plays into the Brady Giglio issue. And the evolutionary process has now been that some aspects of discipline that are imposed, especially against public sector employees, as I say, it started with law enforcement, and now it's moving into other areas as well as people really think this through. But if you get disciplined for certain matters as a deputy sheriff, a peace officer, a public employee, that potentially has relevance if you were to testify in a criminal proceeding. The other side could use it potentially to impeach your credibility. And it's more than just criminal convictions and criminal behavior. Probably the example, some of us who have been around a long time, as I say, this issue starts on the West Coast. But if you remember the O.J. Simpson criminal trial, not the civil one where he was on liable, but in the criminal trial, there was a certain now former police officer who was impeached. His credibility was significantly harmed and impeached on the question of whether he had ever used the N-word or not. He said no, but there was proof that he had. That goes to the issue of credibility. Mm-hmm. If you're going to, which time are you lying? Were you lying then? Were you lying now?
Right, exactly.
The whole issue of false statements and that type of issue. And so we see cases now in jurisdictions where pretty uniformly held that if you are disciplined for certain matters, especially involving dishonesty and false statement, you are going to have that fact disclosed about you to defense counsel anytime you're going to be testifying in a criminal proceeding. What happens if you don't disclose it, and why is this Brady Giglio issue such a big deal? From a prosecution standpoint, there's two possible consequences for failure to disclose. And so therefore, many prosecutors some would argue, over-disclose it. One is the conviction could be reversed. If the appellate court determines your failure to disclose exculpatory impeachment material might have affected the outcome of the verdict or the sentencing, then either the trial could be ordered to be redone or resentencing could happen. So, that has an impact.
One thing I think that's really interesting, I wonder and want to clarify for all of our listeners, is that, and this isn't something that, the defense has got to come in and say, hey, I would like all information on Officer A, and I want all the all the background on Officer B. you have the responsibility to give that. I mean, if you go in, and I remember especially as Brady Giglio got big towards the end of my career, that I would always get a request on so-and-so is going to be testifying. Is there any information? I mean, our prosecutor's office would say, Sheriff Laney, I need any information or any internal affairs issues on Deputy so-and-so. And you provide it. It's not like they forgot to ask so they don't get it. You have the responsibility.
It's our obligation to protect defendants from the malpractice of their own lawyers even, yes. We have a proactive affirmative obligation, even if it's not asked for, to give out this information. And to emphasize how important that is to prosecutors, one of the consequences of a Brady Giglio violation, of course, like I say, is reversal of a conviction, mitigation of sentence. But from a prosecution perspective, what some would say the colon-tightening part of a Brady Giglio violation is they could be professionally disciplined if they don't meet their affirmative obligations. And in my state of Minnesota, what's really taken off and gotten the attention of a lot of prosecutors, as I said, to the point, in my personal opinion, perhaps they are tending to over-disclose, is we have a former county attorney who's now since passed away, and so, I don't want to speak ill of the dead, but we have a former prosecuting county attorney in Minnesota who got disbarred for Brady Giglio violations. Oh. So, losing the case is one thing. Okay, so the person, got to go back and try the case again or cut him a deal, plea negotiation. But when you lose your license to practice law, that's a pretty big deal.
That's huge. Well, one of my next questions, and I think was, why is Brady Giglio such a big deal in law enforcement? And you kind of hit on it there. It could destroy careers.
It can destroy careers of law enforcement, of the government employees, because more and more we see across the country, if you get disciplined for certainly offenses involving behavior involving dishonesty and false statement, even if it doesn't rise to the level of a crime, it's career-ending. The motto or slogan, "You lie, you die," is becoming a national norm. There was and of course, it's career-ending potentially for a prosecutor as well.
Well, I know in my previous life, that was kind of our philosophy as a command staff, and certainly mine as sheriff, is that if I ever had a Brady Giglio issue where I had to doubt that your honesty and integrity, one, if you can't testify in court and do what it is we're here to do, or we can't trust that you're going to be honest, why would I ever let you wear that badge? And I was very strict on that. And I was lucky. I had to deal with certain issues here and there, but never really had a major issue. But that was my policy as well as a sheriff, was I'm not going to let you represent this community if you are a dishonest person. I refuse to let you wear this uniform. And Brady Giglio, if I had a Brady Giglio issue, your career was over. You're done with our organization.
And as you know, Paul, from your life's experience, it can be more than just career-ending. It has had tragic consequences for some officers, including one who killed himself by being declared to be a Brady Giglio cop. And that case is extreme and tragic, but it really illustrates an important point for everybody to be aware of. The underlying behavior that can get you disciplined can often be no big a deal. But if you lie about it, that's the really sad part about these cases. Wasn't paying attention when I was driving. You're right. I hit a patch of ice. I slipped out and smashed up the squat. That's not a career ending. But if you lie about it, it is. That's the career ending part.
And that's the part I think a lot of people, unless you like the public, especially the scrutiny that law enforcement under, 99.999% of cops are the most honest people you're ever going to meet. But like everybody, they make mistakes. And I used to lay it from day one when I'd interview them. The day I gave somebody their job offer, as I laid out the parameters in my drive the road speech and everything that I would do, I would talk about that and say the one cardinal sin that will guarantee you get fired is to lie. Because I always said no truth will ever hurt more than a lie. Because if you make a mistake, you make a mistake. You go into the ditch, as I used to say, by accident, and it wasn't an intentional thing. We brush you off, you learn your lesson, you get a piece of paper, you get your finger slapped, you get a talking to, and you go on your way. You lie about it, even the most trivial thing, then if you're going to lie about a trivial thing, you're going to lie about a big thing. And I can't have you. And that's where you come in and say, it's like, no, make your mistake, but be honest. Take your medicine, and you'll have a very long career.
Several of the last arbitrations that I'm been either a witness, a consultant, aware of in my state, police, law enforcement arbitrations, again, it was that sad moment because often it wasn't the underlying conduct that got him in trouble, it was the lying about it. And what happened is they got fired. It's a career death penalty at this point because they will bring, they being the employer, if it goes to arbitration or hearing, they will bring the prosecuting attorneys in as witnesses and say, we will not take any cases in which this individual is going to be a witness. They're done. Now you go, okay, well, that should be career ending. One practice pointer that I've been teaching, I teach this topic for Northwestern University all over the United States, and one thing I suggest that managers, bosses all do is review your written job description of essential job functions. Because there's actually been case law where people have been fired for lying. They've gone to arbitration. The arbitration result is, okay, they should be disciplined, but under progressive discipline, termination is too extreme, bring them back. To which the boss says, but they're worthless because they can't testify in court. And in one case, at least, the appellate court case said, well, apparently testifying in court isn't an essential function of being a cop. Because if it does, why is it not written in the job description? So one of the things I'm encouraging and suggesting every agency does is review your written job description and the actual language. It's very short. When you list essential job functions, include the ability to provide effective, credible testimony in a court of law. And if you anchor that disciplinary action, you lie, you die, to an essential job function, your lawyer or the court of public opinion or whoever's going to make these decisions say, oh, yeah, I guess. You can't perform an essential job function. It's like having to drive a squad car and you don't have a driver's license.
Right.
Or as an essential job function, the ability to legally and properly handle a firearm. And you get yourself convicted of misdemeanor domestic assault as a cop and can't carry a gun anymore because of federal or state law. These are essential elements to look at. Otherwise, as a chief or a sheriff, you're going to have the nightmare of having somebody working for you that the prosecution has said, don't bother to bring them any cases. Well, where are you going to put those people? Very few agencies are big enough to tuck them away somewhere where they don't run the risk of court. And my focus, our discussion has been about deputies and license cops. But again, in the jail, in administration, who that works in a sheriff's office or a law enforcement agency might not at some point testify. I've had administrative people testify in criminal court. So it pretty much applies to everybody.
Well, in a corrections facility, whether you're licensed or unlicensed, it's more about what it is you got to do. If you're, you could be an unlicensed correctional officer and you're the one that found the contraband during the search, you're going to court. You're going to be doing a report. And I think a lot of people get caught up in that, well, if it's a licensed peace officer, and you're saying, no, you work for the organization and you have to come to court. If you can't testify.
Well, not only you find the contraband, what if you're assaulted? You want a prosecutor to say, well, you were assaulted, and that's too bad, and we would normally charge these cases, but since you're a primary witness, you're a Brady Giglio tainted person, I'm not sure we're going to really pursue this case. Right, or if we do, the bad guy who hurt you is going to get a way better deal than we would have otherwise had to do. So, that's something that we have to recognize. And as I said, the court's focus so far has been in criminal justice, law enforcement, public sector employment, but it's not going to stop there.
So, as a former prosecutor, what categories would you look at when considering Brady Giglio and a witness?
The absolute ones that I'm always going to look at is dishonesty and false statement. And I don't mean just lying to the boss. False police reports, false timesheets, anything that gets somebody disciplined for that kind of intentional falsehoods, those are going to always be subject to disclosure. Most prosecutors, myself included, the rest are going to look at other forms of discipline. How does it relate possibly to the underlying case and how a person might testify on a case-by-case basis? If you were disciplined let's say you were disciplined for mishandling of evidence, and you were going to testify in a homicide, but your only job was to secure the perimeter, I'm not real concerned about that. But what if you were the evidence collector? All of a sudden now that's job related. If you were disciplined for sexual harassment or racial harassment, some kind of situation like that, and now you're going to be a witness in a fourth degree assault in which you or a partner was assaulted, If the person who is the defendant is a person of color and you've been disciplined in the past for discriminatory activity, that's going to feed into the defense narrative that you engaged in misconduct, which could be mitigating. Again, I emphasize, disclosure isn't the same as conceding admissibility. Our motto is disclose and then resist, disclose and resist. And more often than not, that happens. A lot of what the defense wants to argue should be allowed to be put in front of a jury. A good, rational judge will say, under the rules of evidence, that's not admissible. It's not relevant. But if we don't disclose it, we still have that same problem.
Right. Just it takes away any ability for you to fight it.
That's right.
Or to resist it. So what categories consist of a potential Brady Giglio material?
Well, like I say, I think some of them are situational. But one thing I do want to emphasize, from my perspective at least, and I recognize I may be perhaps a little more law enforcement friendly than some of the other prosecutors out there. Unfortunately, in some places, that many of them out there, but I won't even, that's a whole different topic for us to talk about. But one of the things that so far all the case law has said, if discipline is a potential Brady Giglio issue, it has to be actual imposed discipline. In other words, we know that in law enforcement, lots of internal affairs complaints are made against cops that are bogus, for lack of a better word. They're worthless. They're false, even lies. And I've never found any cases as of last time I looked, which was a few days ago in preparation for this conversation. I haven't found any case law at the appellate level that says unsustained, unsubstantiated allegations are Brady Giglio material. It's actual imposed discipline. Now that, whether it's a day off or a couple of days off or more. So that's a big category.
Would a letter of reprimand, letter of consultation be considered that? If there was a disciplinary, like a behavior, something along those lines where, say, it was a consulting letter, but it was a formal part of their file, would that fall into that?
A letter of reprimand is technically discipline.
Right.
Whereas a performance improvement plan or a consultation, say a training session, has not at this point been considered discipline. Now, some of the so-called police reform folks out there are arguing and have argued in some jurisdictions that agencies are trying to essentially hide discipline or substitute letters of reprimand, letters of persuasion, training to avoid the consequences of discipline. I guess that may or may not be true. Most jurisdictions that I'm aware of, it's not, but there's tens of thousands of agencies out there across this country. So I suspect in a few that's probably an accurate discussion.
So would your advice for somebody like, me in my former life and our current listeners is be like, hey, if you got that letter of consultation, give it to you. When I get that letter from Prosecutor Rick saying, do you have any information? I give that to you, and so that you decide whether that's a consultation letter. I'm not going to disclose that or not. But if I don't tell you, and then later on you go, why didn't you give me that? Well, I didn't think it was. I thought it was a consultation letter. We should probably give you the information, let you decide if you're going to disclose it.
I think from a prosecution and law enforcement relationship perspective, that's true, subject to what the public record laws are in your state.
Okay.
If a written reprimand is, for example, public record, as it is in Minnesota, a written reprimand or an oral reprimand document in writing or time off, any discipline that's actually imposed is public information.
Okay.
If it's a training issue, a performance improvement plan, that's treated as generally as private data, private information, which you have an obligation to protect your employees' privacy in that regard. So if you gave those to your city attorney or your prosecuting attorney, your county attorney, you could open yourself up as an organization to a claim that you have violated the privacy rights of your employee. So that's really an important discussion to have, not so much with your prosecutor, because I would venture to guess, and I know this having sort of many hats, the prosecutor in me says, yeah, give it to me all the time, give it to me, and I'll play it safe. But the civil lawyer, sometimes the same person and sometimes from the same office, is going to go, well, hold on. If it wasn't actually discipline, I don't want this, because then we open the agency up for a claim of a violation of somebody's privacy rights. California, for example, has gone through a change where the law has changed there now in the last year or two, but state law in California for police officers up until a year or two ago was a statutory provision that it was improper, illegal, in fact, to disclose discipline of a peace officer without a court order. Now, again, that's evolved and changes. So you really need to look at the specific laws of your state to determine, at what point disclosure is a good idea and at what point it would be, from a liability standpoint, better not to. And don't ask, my suggestion is don't just ask your prosecutors, because this has got a civil component, an HR component that often prosecutors don't know a whole lot about. So make sure you're asking the right lawyers for advice in your particular jurisdiction.
So then from an agency's perspective, what options are there out there for agency's response to Brady Giglio?
Well, the agency's responses are, in most jurisdictions, are typically, I think, a negotiation not only with the agency, but with the prosecuting attorney's office. U.S. attorneys have, since Janet Reno was the attorney general, they have in the U.S. attorney's offices a Brady Giglio coordinator to try and coordinate some of these issues, be the gatherer of records. And they have a little more luxury at the federal level, because if you bring a case to the federal government and they take a look at it, and if they've got a witness, and many of us who've been in the business a long time have experiences, if they've got an important witness in that case that they think is tainted and they would really prefer not to use them, more than once I've said, this is a really great case for state court. Thank you very much. State prosecutors can't do that. Sorry, Mrs. Smith, that guy that killed your kid, well, the primary investigative officer on that's a Brady Giglio cop. We're going to have to kind of let it pass. We're not going to do that. Right. So what are our options? Well, one option is an agency-run, essentially Brady list. You hear a lot of discussion now about people being on the Brady list. Each agency keeps its records and keeps track of its own internal discipline. One of the options that prosecutors have, especially ones that are starting to get nervous about their potential careers, is a number of prosecutors have decided they're going to keep a Brady Giglio list of their own. That's got a huge amount of logistical problems, because you may be dealing with police officers and law enforcement folks from other jurisdictions that you haven't dealt with before. How do you know? So you're still going to have to ask those questions. It's got privacy implications for the officers, for the affected employees. My personal preference is for the agency to essentially keep a Brady list. And then when you submit a case for prosecution consideration and it's charged, you get notification from the prosecuting attorney that a case has been charged, or it's going to go to hearing or trial. Review who's witnesses on that case, and if they have a disciplinary history, convey it to the prosecutor. This allows you to keep your records to the extent you can keep privacy protections for your staff in place. You can do that and still meet your and the prosecution's obligations. What's happening in many jurisdictions for people who are newly disciplined and what's being sustained, an agency option is they simply fire them. And they address the Brady Giglio issue for those people who in the past had an issue, and now it's going to come back to haunt them. How long does it come back to haunt them? So I get asked that question a lot. How do you get off a Brady Giglio list? You die. The evidence becomes less and less relevant over time, like all impeachment evidence. Even criminal felony convictions are generally, under the rules of evidence, at some point get so old that they're not going to be usable in court. But that's a case-by-case basis. So reassigning somebody may be an option for some agencies. I don't know if they meant that on purpose or not, but somebody once told me, I've got this Brady Giglio person, I'm going to put him in my property room. He said, for God's sake, that's the last place on the planet to put these people. You will never have a stipulation to chain of custody again in any prosecution you ever do once the defense attorney has become aware of that. Right. So don't do that. Another option that some agencies have done recently, you may want to think about, is several agencies across the United States that I'm aware of are rolling out body-worn cameras in increments, sometimes for resource reasons or other reasons. And I know several bosses that said, okay, the first people in my agency who are going to get body-worn cameras are the people that are on my Brady Giglio list. So then when the defense attorney wants to start to try and argue impeachment, you say, okay, don't listen to what the officer has to say. Let's just play the video. So that might be an option as well. Yeah. So otherwise, you just disclose it to the prosecution and let them fight it out for people who are already on your Brady Giglio list. Mm-hmm. Another recommendation I have is, especially if you're a new chief, a new sheriff, a new supervisor, if your agency does not yet have a so-called Brady Giglio list, I would encourage you to go back through the personnel records of your existing staff. And again, not just cops, everybody in your organization, and determine, do they have a disciplinary history in their record? And if so, generate your list now. You're way behind the times if you haven't figured something out. It also may help you interact with your prosecutors. If you can say, hey, county attorney, city attorney, DA, we got you back. Anytime we send you a case, if you charge it out and we have any Brady Giglio issues, we're going to make sure to let you know. We've got a policy and procedure in place. So I think those are some of the best options.
Well, we are coming to the end of the show, and as you could tell, we covered about 4 hours of material in 30 minutes. So as I said before, if you're interested in bringing Rick into your facility or into your agency for some really quality training, I can speak from experience, the quality of his training. Reach out to him and we're making an arrangement for him to come see you. Any final words of wisdom that you have for our listeners today? Yeah, don't ignore this issue. Don't think it's the prosecutor's problem. It's your problem. And we don't know where the ultimate case law is going to take this, but it's definitely not going to go away. As part of the so-called police reform movement, we in Minnesota, for example, just one example, there are discussions and proposals to amend our post-board rules that would mandate all Brady Giglio disclosure material not only leave the agency, but actually be provided to the post board as well. So this topic isn't going to go away. Get in front of it. So deal with it. Deal with it. Exactly. And make sure your staff know that you lie or die is not just a slogan. In the modern era, it's the real deal. Well, thank you so much for your wisdom and your time today, and I'm sure we're going to have you back as often as you can come back, just because your knowledge, obviously the legal issues within the law enforcement and jail environment are huge, and here at JailTalk we want to provide you with as much knowledge as we can. So thank you. Thank you for your time. We appreciate it. Thank you both. Thank you. And thank you, everybody, for listening. Make sure you subscribe to our YouTube channel and follow us on Twitter and Instagram. And if you have any comments or questions or know anybody that might want to be featured on the show, make sure you email us at jailtalkpodcast@gmail.com. Well done. Thank you. I'm Paul Laney. And I'm Lauren Matthews. This is Jail Talk. We'll see you soon.